Good morning, everybody. And I have a presentation there with slides, and obviously the time doesn't allow me to go through it all, so I'll deal with some of the main points. So what I intend doing is to concentrate a little bit on our existing situation and then pick up where the legislation is going to deal with that and make some comments on that. So basically I'm going to talk about the bill, but in particular specific issues. So if we look at existing structures, in terms of the definition of capacity, first of all, it's not defined in any legislation. Our 1871 Act is very much a procedural act. It's not defined at all, and I'll come back to that in a minute. So many different approaches apply. We have the functional approach in relation to lots of issues at common law, making a will, entering into a contract, entering into marriage, voting, all of those issues. We have the outcome approach very much in the medical context, where the unwise decision or the disagreement with the decision a person is then found to lack the capacity. And then we have the status approach, which is across the board, based on the medical model, if you're dementia, intellectual disability, rather, and in fact, in spite of the fact that we have that presumption of capacity in common law, we still then deal with it as a status basis and deal with it on that basis. The presumption of capacity, I say, is in common law, but is actually ignored in practice. So the legislation will be picking up on that, and the legislation will now say, have particular legislative provisions to say that that presumption is there and it must be followed unless it's clearly indicated to the contrary. Next of kin, we have a huge cultural shift to make on this. I've been talking about this for, I'd say, 15 to 20 years. And yet yesterday, I'm still being asked those questions about next of kin. So we have to get our heads around this, and even looking at the legislation in terms of all our obligations of intervention with people whose capacity is at issue, I still see that there's possibility of traps there. So culturally, we have to shift and get into that correct space. And that is really down to a lot of professionals in practice. And a lot of education has to go into that. So there's absolutely no emphasis on the person's individual rights and wishes at all in any context at the moment, in spite of our constitution, in spite of all our signing up to international conventions, etc., and I'll come back to some of those. Enjoying powers of attorney, no current provision for healthcare provisions, no proper reporting requirements, a huge facilitative tool for people planning in advance, but currently a huge tool of abuse, particularly for older people, particularly in the financial area. Advanced healthcare directives, legally valid and recognised for many years by many court cases, but in practice completely ignored, and we've no statutory basis for it, so legal uncertainty. The right to privacy and confidentiality, hugely ignored in practice. Even though people are still talking about doing all the right things in the functional approach, taking the person's wishes and everything, they will still discuss those wishes with next of kin, whoever, and the person may not wish their next of kin. And who is the important person in that person's life? So, in the debate we're having elsewhere in terms of people with different sexual orientation, etc., who is the important person in that person's life? So those are the issues that we have to really come to grips with. Wards of court then, on the other hand, as I said, it's the status approach, the old 1871 Act, completely archaic, deals with property rights, and no participation by the person the subject of the application. I would say that in spite of our constitution, a prisoner has very detailed rights to appear and to have his accused say whatever. A person whose capacity is issue currently does not appear before the court at all, and yet that huge decision is made about them and taking away their decision-making capacity, even though we know some of them have capacity to make decisions. There is no review, and interestingly enough, the 1871 Act provides for a review, but we didn't carry out reviews for many, many decades. So we have huge issues to tackle in our legislation. Deprivation of liberty and restraint, again, comes within our constitutional provisions and the European Convention of Human Rights and the UN Convention of the Rights of People with Disabilities, but we actually have completely ignored it. The draft legislation didn't deal with this adequately, and I'll come back to that as well. So there's an overemphasis on risk prevention versus the benefits on the rights of the person to choose and the happiness and well-being of that individual. So our legislation can do a certain amount, but I can't overemphasise that cultural shift that we have to make with the basic rules in place to assist us to get into that space. The right to private property, issue of financial abuse not addressed, and the cultural right to inheritance. And I was delighted when I was driving back last night to hear Olivia O'Leary on the podcast. I'm sure some of you heard her. Please download it, replay it, listen to it, tell everybody about it, give it to all your family members, etc. So coming back to the Constitution then, we have the Constitution, and the rights are set out there, as I've said many times, but we haven't actually associated those rights in the Constitution with a person whose capacity is at issue. And that's where I think we have the mismatch. And in 1996, we had the Wards of Court case, which basically said those rights, a person who lacks decision-making capacity or who has a disability in terms of their mental functioning, has the same rights as everybody else. And in fact, that is what the UN Convention on the Rights of People with Disability is saying. And we're now paying attention to that UN Convention. In fact, it's there in our Constitution, and it was highlighted in that Wards of Court case back as far as 1996. So hopefully we get there. The European Convention of Human Rights, again, in our 2003 Act, we actually signed up to say that we would interpret all our laws in compliance with the UN Convention. And of course, also the 2003 Act says that we must comply with all the decisions of the European Court of Human Rights. And notice must be taken of all those decisions. And that's where now some of the issues with regard to deprivation of liberty is coming from. UN Declaration on Bioethics. Again, the issue there is right to consent and refuse medical treatment, which again is a fundamental legal principle in common law. But what that convention is saying, that regard must be had again to the people who lack capacity. They have the same right to consent to and refuse medical treatment as everybody else. So equal legal rights. I'm moving on then to the principles concerning powers of attorney and advanced healthcare directives, Council of Europe, which we're obliged to abide by. And going back to Minister Lynch's point about planning ahead, what that is saying, states have an obligation to put in place and to facilitate people to plan ahead for their future, and I'll come back to that. And then last year, the recommendation on older people, emphasising older people have rights and have rights to make all sorts of decisions, including the right in relation to their finances, where they live, where they should reside, all of those issues. So extremely important issues. So we have the assisted decision-making capacity legislation. The bill was published in 2013, provides the capacities to be construed functionally. Advanced healthcare directives, the Department of Health published a scheme of the bill in 2014 to be incorporated into the assisted decision-making capacity legislation, because of course the issue of capacity is extremely important in that context. And while we have the 1996 Act for enduring powers of attorney, that will be extended to include healthcare decisions. So the purpose of the legislation, so I've identified to you all the lack of our regard to respect those human rights. So the purpose of the legislation is to promote and protect the human rights, which include the right to inherent dignity, extremely important, again, which we ignore, right to privacy, which we ignore and continue to ignore, bodily integrity, medical treatment, etc., self-determination and autonomy, to ensure that all persons are treated on an equal basis with others. So people with disabilities have the same rights, people who lack capacity have the same rights. The question is, how do we understand what their wishes are? So to ensure any necessary intervention that is necessary is to maximise the decision-making capacity. At the moment we have this medical model where we find a disability, we assume they lack capacity. We have to switch to the human rights model to maximise the capacity and to then absolutely make sure that that person is facilitated to exercise their legal rights and their legal capacity, even though they have a mental capacity issue. Autonomy and self-determination. So I'm going to, just to say the definition is there, the capacity, the legislation sets it out, the ability to understand the nature and consequences of a decision to be made by a person in the context of available choices. Again, in assessing capacity, we never give anybody the options, we just ask them questions. We do psychological tests, we do mini mental state examination, no relevance to the decision they have to make. So who's the President of Ireland? It's nothing got to do with where I want to live or what medication I have or anything. So if we can face into those issues, and again, that's why I have great difficulty in the current situation. And coming back to the FK case, sorry, did I mention the FK case there? No, in terms of the existing structures. The status approach. In 2007, Mrs. Justice Mary Laffoy made a decision of how capacity should be defined and how it should be assessed. And I reckon, and of course I'm biased because she relied on a lot of the work done by the Law Reform Commission in recommending the way the legislation should go. I reckon since 2007 that is the correct definition and way we should assess capacity. For me, for the life of me, that was a decision of the High Court. I do not understand why the High Court is now not currently following that. Of course, post that decision in 2008, we have the Hse Consent Policy based on that functional approach. We have the HICWA based on the functional approach. We have the Mental Health Commission following the functional approach. We have the Medical Council guidelines in 2009, the ethical guidelines that were changed to take account of that issue. So for the life of me, I can't understand why we're still in that awful space. And so any of you involved in wardship, I would say you should be asking about the functional approach even now, but we do need those basic rules in the legislation, so there's no lack of understanding whatsoever. Just time, and these are in the slides, how capacity is to be assessed. Extremely important. A person is not to be regarded as unable to understand information relevant to the decision if they are able to understand an explanation of it given in a manner appropriate to their circumstances. So what is the decision they have to make? What are the circumstances? What is the information they need around that decision? And that is what the legislation is trying to get at. And again, the reasonable and foreseeable consequences, they must be given the information. And again, I would be critical of the draft bill in terms of that lack of interaction between people who have a mental illness and may also lack decision-making capacity. And I was very interested to see the review a week or so ago, the expert review group, picking up this point about the whole question of dealing with that, and those people having the right to have the information about the risks and those foreseeable consequences in mental health, even though they're being involuntarily detained. So extremely important developments in the legislation. The guiding principles then, we have a set of those guiding principles which are set out in detail. The unwise decision, if anybody have access, Google the FK case in England. It's a fantastic case for all sorts of issues. Haven't time to go into it now, but the question that we're all entitled, people with a disability, without a disability, all entitled to make unwise decisions. But very importantly, no intervention unless it's necessary. So minimise the encroachment on a person's decision-making capacity. The principle sets out the obligations on any intervener, you or I, all of us who are intervening, trying to assist or supporting or interfering or whatever with a person whose capacity is at issue. So to minimise the restriction on their rights and to minimise the restriction on their freedom of actions. And then sets out the obligations of facilitation of the person, etc. It sets out then the decision-making interveners, etc. And I'm just, as I say, I'm moving on. What's extremely important in the new legislation, there will be a review of all existing wards of court. So the legislation itself is recognising there are many people currently in the wardship situation who have the capacity, maybe to make all their decisions, maybe to make some decisions, but there's going to be an assessment to see what category do they fit into. And so they will be discharged from wardship and appropriate orders will be made. So my first question is, if they have decision-making capacity, the whole question of facilitating them to plan themselves in advance to do their EPA, their Advanced Healthcare Directive, and then go into the other streams of assisted decision-making, appointing somebody themselves, co-decision-making, and we have those 3 levels in the legislation. And then, if they lack capacity, somebody will be appointed to assist them also. So it's terribly important. I disagree with the 3-year review period, but however, at least we're having that. There's a recognition of those people's rights, which is extremely important. So I come then to the planning ahead, and thank you, Minister, for actually emphasising this point. There are 2 issues, I suppose, I would have here. One, that we have that 1996 legislation since 1996, and yet I'm still interested and concerned and whatever to hear not many people know about doing an EPA or appointing somebody. And if they do, they appoint somebody that maybe not a suitable person or whatever. But the real issue here is that right of self-determination and autonomy. So the first thing, what the Council of Europe was saying, that states must ensure that they put facilities in place so that a person, first of all, has that facility before going through any court process. And at the moment, we wait until the person lacks capacity. We don't encourage people to enter into that. Now, on the one hand, there's the human rights element of the person and making sure that we actually establish at whatever stage we can their wishes, what they want and what they want to do, and also to assist them to appoint another person. On the other hand, I'm flabbergasted and I use the word flabbergasted, at the amount of state resources that are put into a situation because we have no pre-planning done. And I heard Minister for Health a week or so ago when he was getting 75 million for delayed discharges, and the whole issue as whether that would free up, and we all know that one of the issues is the delayed discharges is proper care for older people that have been in the acute service. And he said that we will still have some problems. And the interviewer asked, well, what are those? Well, he said there are some people who have to be taken into wardship. Now, why I'm asking, and when you think of the social workers, the healthcare professionals, and they're in this confused state of trying to ascertain what is this person's will and preference, and they're the good people who are trying to establish that. On the other hand, decisions are being made completely ignoring people's rights. So I think the government should have a campaign to actually promote the whole planning in advance. And the third issue on that is the demographics, where we're going to. We can't go on this situation. So moving on then to enjoying powers of attorney, and I'm going to just highlight some of the particular issues at the moment. So just to highlight, first of all, healthcare decisions or healthcare matters, so we can appoint an attorney for healthcare matters once the legislation is passed. What additional safeguards? So the general principles will apply to the EPAs, which is extremely important. So even though a person has actually made an EPA, appointed somebody to make their decisions, the legislation will still provide that the functional approach applies and that a person must be asked and assisted and their wishes ascertained at that time. While the appointment is there and in place. At the moment what happens, a person is appointed, the attorney takes over, makes all the decisions, takes all the finances and all the rest. The issue of a suitable person, at the moment under the current legislation, we have people who are debarred from directors of companies, meaningless in relation to abuse of an older person in the family context. So we have increased exclusion of certain people. So, and again, we see in the courts of domestic violence, a huge number of cases going through of adult children, violence against their frail older people. So it's capturing some of those issues. The reporting requirements going to be much more detailed. At the moment, a huge amount of formality is incurred at the stage of when a person is making the enduring power of attorney. Once it's registered and the person lacks capacity, there is currently very little control or oversight. And again, the legislation is picking up on that. So the attorney must prepare and submit periodic reports on the performance of their functions. So in other words, all issues pertaining to the person, their well-being, health, as well as their property matters. So that's important. And they must include details of all expenses and remuneration. And during the Celtic Tiger years, we had huge abuse of transfer, generational transfer of property, abuse of older people, where people were transferring their homes, nowhere to live, put into the nursing home, etc. Huge abuse. And we did that, thought that was great, getting it, saving tax, all of it. So listen to Olivia O'Leary. Then the whole question of gifts. I feel the legislation hasn't covered that, the draft legislation. Hopefully we'll see more in the final piece of legislation. In the draft legislation, I reckon the issue of undue influence wasn't dealt with adequately. I now understand that there will be more safeguards put in at the initial stage, because once the person has made the enduring power of attorney, when it comes to be registered, it's far too late, they lack capacity. So a lot more front-loading of safeguards. Again, on registration, I understand, again, huge abuses. One, at the moment, enduring powers of attorney, to come into effect, have to be registered. People don't bother registering. People go along and say, I'm the attorney. Everybody believes that, never asks for a copy or whatever. So again, much more scrutiny of at the registration time by what is now going to be called Decision Support Service. That's what I'm assuming, unless it's changed in the last few weeks. But anyway, and that Decision Support Service officer, or whoever, will have the task of scrutiny. Then other issues. So the copy, again, of the registered EPA can now be obtained. So anybody dealing with a person who presents as the attorney, and we had a case a couple of years ago where somebody presented to the High Court and said they were the attorney, and the High Court was looking for the registered enduring power, which should have been registered in the High Court. So you know where he ended up, not in a nursing home, some other involuntary detention place. But in any case, so again, a very important point. Again, it will ensure that the will and preference of the person have been taken into account. And what's very important, that office, the support service office, will have an educational role in all of this. So extremely important. And then the Hague Convention, which I think, again, people moving from country to country have property in different countries, and the legislation is picking up on that as well. So moving on then, I'm very conscious of the Advanced Healthcare Directive. The legal principle I've set out, the difficulties, uncertainty in practice, and the legal right, particularly of people who lack capacity to make that. And just to emphasise, what is the difference between a healthcare attorney and an advanced healthcare directive? Well, a healthcare attorney, you're appointing a person to act on your behalf. An advanced care directive, you can write a piece of paper when you have capacity to say what you want when you lack capacity. But it will also provide that you can appoint a person to make decisions. And I think for older people, that's extremely important. There are quite a number of formalities, quite rightly, in relation to the execution of an enduring power of attorney, but the formalities will be less for an advanced healthcare directive. As you can imagine, some of those care decisions are at the last minute, and if people are ill, etc. But what is very important is that the legislation sets out what the purpose of it is, and that is to promote the autonomy of persons in relation to their treatment choices, to enable persons to be treated according to their will and preferences, beliefs and values. And again, I haven't time to get into the whole best interests, I'd love to, but anyway, will and preferences. So if you can find out what the will and preferences, if you can't, you're on to beliefs and values. So who do you talk to find out what the beliefs and values? My difficulty with the legislation is where you have gone through those categories and you're left then what is, as the English Court of Protection would call, what is the value judgment and who makes that call at the end of the day. Now, in the healthcare area, that is the clinician, and their whole ethical guidelines deal with that. In the non-healthcare area, I think there's a little bit of gap there in the legislation. But anyway, maybe the final bill will have more of that. But also, very importantly, to provide healthcare professionals with important information about persons and their choices. Additional guiding principles, which are, in addition to those I've already articulated, terribly important, because these are picking up from the cases over the years where people were saying, no, you can't refuse on religious grounds, or you can't you refuse life-sustaining treatment. So the legislation is making it quite clear, if the person who had capacity, informed decision-making, voluntarily made their decision, their right and decision has to be respected. Basically deals with treatment refusals, because obviously I can't request things that are not clinically indicated or whatever. However, for older people, the code of practice and the care plan and their wishes is extremely important. It is not euthanasia-assisted suicide, it is recognising the right of a person who lacks capacity of their right to consent and refuse medical treatment, taking up the basic legal principles. Very important, I think, is that you can appoint a person, a named person, so for religious orders, it's not the superior for the time being or whatever, and I've had that quite a little bit, so interesting. And again, the power can be limited to whatever the person decides, or can be a very wide general power up to and including life-sustaining treatment. There will be liability if it's not followed. The conscientious objection issue of the medic who doesn't want to carry it out, covered. The rights of the person is the dominant right, and the European Court have dealt with that on many occasions. If the person who's objecting can be facilitated, if they can't, if you're in the Aran Islands and the only medical doctor there, then it is the right of the person, the patient, to decide and carry out and respect their rights. Very quickly, and this is a very serious subject, again, it's a thing we've buried our heads in the sand. European Convention says we cannot detain anybody except in accordance with procedures prescribed by law. Those exceptions are prisoners under the criminal law and involuntary detention under the Mental Health Act. Yet we detain many older people, we detain people with disabilities without any procedures prescribed by law, and etc. And again, I point out the 2003 Act. There have been very many cases before the European Court on this issue. We, under that 2003 Act, are obliged to follow those decisions in the court. We are not following them. The UN Convention on the Rights of People with Disabilities, making that point again in conformity with the law. Where is our law? While we have policies, etc., we had, again, cases in the UK Supreme Court last year, which actually were following the European Court, and I know a PQ was asked in the Dáil about this issue. So I understand that the final piece of legislation will set out the principles and will have safeguards, which I think was a deficit in the draft bill. Meanwhile, though, we have to rely on the national policy documents that are there. Some of them are good, some are very high level, some of them are not helpful as to the practical realities of dealing with very challenging positions. A person has a right to have their property protected, and I know I'm galloping here, but a very important issue, the financial abuse of older people. The joint accounts, the biggest tool of abuse, financial abuse, is that joint account. And again, when you're going around and asking people, and I did a week or so ago, spoke to stroke victims, they all had planned the joint account. It was all going to happen. And of course, the joint account, if it is purely a convenience agency account, once they lack capacity, it automatically becomes void. It's not operable. I have asked, I have pleaded, etc., for this to be covered in the legislation, and I know it's in draft legislation for trust law. Hopefully it'll be catapulted into this piece of legislation. State pension, huge tool of abuse. for many, many years. And of course the department look at fraud in the department, they don't look at fraud of the individual person. So in other words, if the pensioner is getting his pension, they're not too concerned. However, as a result of Hse Financial Abuse Group about 2-3 years ago, we succeeded in getting the Department of Social Protection to get noted on that joint bank account that it was an agency account. So some improvements there. I think it's worthwhile quoting the Supreme Court decision in 2004 where the nursing home legislation was going through. So the Supreme Court said the Constitution in protecting property rights does not encompass only property rights which are of great value. It protects such rights even where they are of modest value, and in particular, as in this case, where the person affected are amongst the most vulnerable sections of society and might more readily be exposed to the risk of unjust attack. And we all know that the research that was done by NCPOP, the National Centre for Protection of Older People in UCD, the older, the poorer, the only income being the state pension, the more challenged mentally the person was, the higher the level of financial abuse. So just to say, on financial issues, we have a little bit of movement. In 2006, the Law Reform Commission spent a long time trying to persuade the Central Bank to have something in the 2006 Consumer Code on vulnerable adults. Thankfully, in 2012, there is now something there. I do believe still not sufficient, but at least something is there, so there's some provision. Law Society regulations, solicitor acting on both sides in a voluntary transaction, facilitating Celtic Tiger transfers, for example, to the next generation. And again, the Law Society, who are entitled to make regulations, that proposal and recommendation was passed by one vote. And we had the IFA, the Irish Farmers, Cream and Milk Suppliers Association, actually outraged that you would have to have two solicitors in these matters, totally ignoring. And again, the cultural issue, all they were concerned with the farmer getting the land, etc. They were not concerned with the older, vulnerable person where they were going to live. So we've huge cultural issues apart from any legislation. As I said, the joint account will be. So, oh yes, the legislation includes offences, people who ill-treat or neglect a person. In the bill as drafted, that is confined to certain categories of people within the bill. I feel that should be a general provision, and I will be very disappointed if it's not a general provision. The issue of research, again, not provided in the legislation. A person with dementia is entitled to be part of research to improve their decision or whatever. That should be chemical restraint, not dealt with in the draft bill. I think it's a huge issue in nursing homes. I think we need to address it. Again, it's one of those fundamental rights in the European Convention of Human Rights where a person is not to be subject to inhumane and degrading treatment. And chemical restraint is inhumane and degrading treatment. It is not medical treatment. And people don't distinguish between chemical restraint and actually the appropriate and proper therapeutic administration of drugs. So a huge issue. So as I understand it, we didn't hear anything further, Minister, this morning on this. My understanding is it's to be debated before the Justice Committee in May and to be enacted this year. The question of operation then, obviously, a lot of work has to be done. My own view is advanced healthcare directives. They're there already. That can be accelerated. So hopefully that will apply. And I put up those two very important issues or organisations for older people. Many thanks. Thank you.